Good morning, everybody. I'm Brad Henry. I am a partner at Michelman & Robinson. I'm the co-chair of the dispute and resolution practice and the chairman of the white collar investigations practice. And just want to take a few minutes to welcome you this morning with Altu, my colleague from Chet and Kaya. We're very pleased to spend this time with you. Thank you so much for coming. You know, the FCPA is a very timely topic. It's something that is important, I'm certain, for all of you. And in terms of the U.S. perspective and the Turkish perspective on that, we hope to give you some insights on the interplay between the FCPA and, for Turkish companies specifically. We appreciate you all coming out. Hope you enjoyed your breakfast. We're going to break the event up into two parts. The first session, Kathleen Bourdieu and Altu will be speaking to you, and in the second session, I, Bentley, and Mehmet will be speaking. We'll have some time to talk to each other in between. If you have any questions, we're going to have a Q&A session both after the first session and after the second session. And we look forward to meeting and talking with all of you, and I'll let Altu say.
Thank you, Brett. Now I want to invite Kathleen and Burcu to here to discuss.
Thank you.
So can you please first introduce yourself and give us some thoughts about?
Hi, all. My name is Kathleen Shannon, and I am an associate with Michelman & Robinson in the White Collar and International Arbitration Group. I initially, out of law school, started in the private practice doing white-collar defense work, and then I was in the government, so I was on the other side for a few years doing investigations and compliance, and now I am back in the private sector, so I have a little bit of a unique perspective in that I've got the private sector and the government side, but happy to be back on the defense side. And happy to be here today. And I am going to sort of give an overview of the FCPA, and then I'll sort of look at some trends from this year and a little bit of 2021, and then also some of the policy and political developments going on in DC and what that means going forward for enforcement. So.
Okay. The floor is yours, so if you can get an overview about our white paper and some merits of the FCPA, it will be really nice.
Yes. So the Foreign Corrupt Practices Act, at its core, generally prohibits making corrupt payments or giving anything of value to foreign officials in exchange for obtaining or retaining business. So there's two sets of provisions, and they're enforced by two separate U.S. government agencies. So you have the anti-bribery provisions, and then you also have the accounting provisions, also frequently referred to as the books and records provisions. The anti-bribery provisions are enforced by the U.S. Department of Justice, and the accounting provisions are enforced by the U.S. Securities and Exchange Commission, which oversees U.S. companies that are publicly traded and also certain types of companies that are otherwise regulated. And the accounting provisions are, well, the anti-bribery provisions speak for themselves. They're to prevent bribery, but the accounting provisions are designed to prevent accounting practices that are meant to hide or disguise those corrupt payments. So disguising bribe payments as legitimate business expenses in your books and records, and that is a very common theme that you see in a lot of cases. And even though you have the SEC and DOJ both working on separate provisions of the Foreign Corrupt Practices Act, they do collaborate, they work very closely, they share information not only amongst each other but also with other government agencies. So getting in trouble with respect to the FCPA can sometimes also trigger a domino effect, and then all of a sudden there's, OFAC and Treasury sanctions get involved or other types of crimes. So it's very important to focus on FCPA because if they start poking around, then they share information with other government agencies, and then the charges can start piling up, which is never good. But and one unique, actually probably the most unique thing about the Foreign Corrupt Practices Act, the thing that makes it so scary, frankly, is the fact that it has this cross-border enforcement power all around the world, what we call long-arm jurisdiction. And so the US government can bring Fcpa enforcement actions where, there's seemingly where there's a lot of companies that would think, oh, there's no way that the US government can prosecute me for this. But again, it's like the long arm reaching across the ocean to prosecute people. So the Foreign Corrupt Practices Act, of course, they can enforce it against all US-based entities, but wherever they're operating around the world, and all US citizens, wherever they are in the world, as well as all foreign subsidiaries of US entities, and foreign entities that have US subsidiaries or engage in business activities in the US, even if the corrupt activity takes place outside of the United States. And finally, and again, one of the scarier things is that there is individual liability for people, foreign or US citizens, anyone that works for one of these companies or acts on behalf of them as a third-party contractor. So the long-arm jurisdiction of the US government with respect to this law is, yes.
May I ask a question about the scope? So you mentioned that it's extraterritorial, a long-arm legislation. So do we fall under the scope if we use the payment terms of United States, like if we bribe a government official in United States dollars?
So like a sanctions type hook. Usually, I believe there has to be more than just using the U.S. banking system. There has to be significant commerce or a business presence in the U.S. or you're a U.S. citizen or a subsidiary. So, and also it's very, very important with the third-party liability, where Fcpa violations are committed by a third-party contractor, such as a vendor, sales agent, marketing company, on behalf of companies that are subject to the jurisdiction. That liability for that action flows up to the company that is benefiting. So, and third-party contractors represent some of the highest risks that are related to Fcpa enforcement. That's where we see a lot of problems, but there's also a huge opportunity there for compliance. So on the other side, and making sure that you are talking to training your third-party contractors, and you have the anti-bribery provisions in the contracts, things like that. But third-party liability is definitely one of the biggest trends out there in enforcement. And so when it comes to what type of activity violates the Fcpa, there's these core 5 elements. So I'm going to run through them, but just so you know, they are on page 3 of our white paper. So you have to have 5 things. You have to have a payment, offer, authorization, or a promise to pay money or anything of value to a foreign government official, which includes party officials or employees of state-owned entities, or to any other person, knowing that ultimately that payment, that benefit is going to get passed on to a government official. So just because you pay a middleman, a strawman who's not a government official, if that money is going to the government official at the end of the day, that is considered payment to a foreign government official. You see companies sometimes try to say, oh, but I gave it to this guy, but that doesn't matter. And there has to be a corrupt motive. And 4, for the purpose of influencing an act or decision, or to secure an improper advantage, or inducing a person to use their influence to effect an official act or decision. And finally, 5, it has to be for a business purpose. So in order to assist in obtaining or retaining business for or with or directing any business to any person or entity. And again, that's all on page 3 of the white paper. But so those are the 5, the 5 elements that you need. But then it sounds simple, but it's not, because payments are not, under the Fcpa, are not just money, these improper payments. Fcpa violations cover more than just your traditional bribery, your person handing off a bag of money to someone in an alleyway. That's sort of what you think of as your traditional bribery, but the Fcpa covers a lot more than that. It covers what I like to call your non-traditional bribes. So include in terms of payment, so political and charitable contributions or donations. Sometimes you'll see in cases people will make a donation to a political party in order to get their construction project approved, their grant approved, or to win a bid, something like that. But then there's also the non-monetary benefits. So the law says payment, but the DOJ and the SEC have continued to sort of expand and be like, well, it's not just payment. It can also be non-monetary benefits. So travel and entertainment, lodging, gifts, scholarships, offers of employment, offers of internships. And another unique thing is that promising not to do something, DOJ and SEC have also found that can be considered a payment under the Fcpa. So, for example, forgiving a loan, if someone owes you money, saying, if I'm going to wipe away this debt, you don't owe it to me anymore. So, to sum it up, the definition of payment is extremely broad, and a good example of this is, an FCPA case where violations were found when a company provided internships to the children of Chinese government officials.
JP Morgan case, right?
Yes, and so they found a few. It was called the Princeling cases, is what they called it. And one more thing is that there's no minimum threshold. It doesn't have to be $1 million. It doesn't have to be, the gift that you're giving doesn't have to be a Rolex or something like that, or it doesn't have to be a really lavish trip. There's no minimum value threshold under the Fcpa, which is very tricky for a lot of clients and companies to understand, because there's often situations where you're taking people out to dinner, but you have to have all 5 of the elements. So it's, but again, there's no minimum threshold. And when it comes to government officials, who's a government official? It's not just, a lot of times, again, when you're thinking of a bribe, you're thinking of your high-level power players, so to speak, like your ministers, cabinet secretaries, elected officials. But this also, the Fcpa covers ministerial and administrative government officials as well. So, just general workers and regulatory agency employees, customs officials. You'll see a lot of issues related to customs, military and defense employees, and especially those that are involved in choosing who receives contracts, like very lucrative military contracts. And also employees of state-owned businesses. So that could be school systems, public hospitals, public clinics. So that's definitely something to keep in mind, because it's not just your fancy elected officials, where you do have those cases, but you also have just people paying off regulatory employees to get improper benefits. And another thing, which is quite surprising to a lot of people, is that the bribe does not actually even have to be successful. You don't have to pay it. You don't have to get what you want. Under the terms of the Fcpa, bribes don't need to be paid or completed. There doesn't need to be sort of that quid pro quo necessarily. It doesn't have to be completed. So even an offer or a promise can constitute a violation. And the business purpose was one of the 5 elements. And so in order to constitute an Fcpa violation, A payment must be intended to cause an official to take an action or make a decision that would benefit the bribe payer or the gift giver's business interest. And the business to be obtained or retained by the corrupt payment, gift, loan forgiveness, whatever, doesn't actually have to be with the government or a government-owned entity. So the FCPA, you can violate the FCPA if a corrupt payment is made in order to facilitate obtaining business, even if it's with a third party, just so long as there's that intermediary step with a government official. And one thing we get a lot of questions about is there is an exception. So, and a lot of people ask about the exception. So the FCPA does technically contain a exception for facilitating or expediting payments. So think payments made to government officials to perform routine government actions. So obtaining permits or licenses, processing visas or work orders. But it's a very tricky area. While there is an exception in the law, DOJ and SEC have just completely pretty much obliterated that through case law, through their interpretation. It's so narrow now that you really never ever see the US government decline to prosecute because they're like, oh, okay, that wasn't a bribe, that was a facilitation payment. Moreover, labeling a bribe as a facilitation payment or expediting payment in the company books does not make it one. You do see a lot of cases as well where the companies try to argue, you know, it's in our books and records, but that just ends up getting them the SEC accounting books and records violation. So again, there is an exception. It's extremely narrow, and companies should really operate under the assumption that the exception does not apply. You have to really, really be careful about that, and especially when it comes to the books and records as well. So that's sort of an overview of the law itself. There's always more to discuss, but that's the very basics. And so going now to the year so far in review, I will note that in 2020, there were so the value of settlement amount was $6.4 billion US dollars. And that was, I believe, with 12 enforcement actions. And that is the largest amount ever. 2019 was the record, but 2020 now just completely blew through that. And 2021 so far, as of an hour ago when I checked it, there's been 183 million US dollars. That's the value of settlement amounts as of today. But as I've said to a few people in here, I think we could get some more cases this week, next week. They're starting to really ramp up again. So I don't think we'll hit the $6.4 billion benchmark unless there's, you know, a few really, really big cases to come in, but you never know. And I do think that looking forward, 2022, is also going to be quite large because of the COVID pandemic. They weren't able to, there was a slowdown in the way that they were able to enforce. So they've got a big backlog that they've got to catch up on. And we are going to discuss later about some of the trends are, more emerging markets. That's where a lot of risks are, especially when it comes to permitting, construction, infrastructure type issues. That is a hot area. And so I will talk about just a few recent cases, like very recent, as in this one was, so WPP was September 24th, and it is the world's largest advertising group, and they paid the SEC, this was a big one, it was a $19.2 million US dollars to resolve charges that it violated not only the anti-bribery provisions, but also the books and records and internal accounting controls provisions of the FCPA. And so WPP is based in London and New York. The penalty was $10.1 million in disgorgement, So the money that they made off of their bad deeds, and some prejudgment interest, and also an $8 million penalty. And this was based on activity of one of their subsidiaries in India, which bribed government officials in return for advertising contracts, even though WPP, through their compliance program, had received 7 anonymous complaints of talking about the conduct. So that just goes to show that you can have a compliance program in place with a whistleblower hotline or anonymous email inbox. There's several ways to do that, but if you ignore when those tips come in, that is something that will make the government officials very angry. That's definitely an aggravating factor. And the SEC also alleged that there was widespread corruption through the company in other countries, including China, Brazil, and Peru. Another one that was released June 25th. So this is a difference, so that was advertising, just to show that this touches all different types of industries. Amec Foster Wheeler Energy, they paid the DOJ and SEC a very big one. It was $41.1 million to resolve criminal and civil FCPA charges. And this was a scheme, a gas to chemicals complex. It was a scheme to bribe Brazil officials to win contracts to design a gas to chemicals complex there. And let's see, they did also, we'll talk about this a bit later, but there was a deferred prosecution agreement involved there, but they still, have to pay a lot of money. And I will highlight 2 cases quickly that involve individuals, which I always think are some of the most interesting ones. Sometimes they stem out of previous settlements that were with companies, and sometimes they are one-offs. It really just depends, and sometimes that can depend on the cooperation of the company itself. So there was a Asante Burko. This was also June 2021. He's a dual citizen of Ghana and the US, and he paid the SEC, this is lower, but again, it's an individual, so it's actually quite high, $275,000 in disgorgement, and then also $54,000 in interest to settle charges that he violated the anti-bribery provisions. And he was a former Goldman Sachs executive, and he allegedly helped a Turkish energy company win a power plant contract in Ghana by arranging and paying bribes through an intermediary. So again, that's where you have that, there was that argument that I didn't actually pay the government official, I paid an intermediary, but that is not a defense. And the bank is the one, Goldman Sachs was actually discovered this bribery and reported it. And so Goldman Sachs did not end up being charged, just the individual was. So that's another, I sort of enjoy going over the main topics and then highlighting a few cases that display in real life how these things shake out. And one more that was an individual, this is a guilty plea. This was in May 2021, and it was a Canadian citizen and a founder of an energy startup. He pleaded guilty to a count of conspiracy to violate the FCPA for his role in paying $2 million in bribes to the former ambassador of the Republic of Chad to the United States to secure rights to an oil block in Chad. And he, as part of his guilty plea, he agreed to forfeit his proceeds of approximately $27 million. So this, to me, is an example of that traditional bribery. You've got the high level, just money being handed over, and it's to a very high level, an ambassador. So that one I thought was interesting because it is an example of just your traditional bribery, not your more creative So looking ahead now, so obviously in the US, we have had a presidential administration transition, and that really does affect enforcement trends, because all the political officials that were there, that were in the Trump administration, are no longer there. Then the Biden administration comes in and they have to vet everyone, look into everyone's backgrounds, do all the job interviews, figure out who to give the jobs to. And in some cases, for the high-level Department of Justice and SEC positions, you have to go through our Congress and do hearings in the Senate, answer a million questions, make all your financial disclosures going back 20 years. It takes a while. It's a long process. And then every senator and congressman stands up and asks you questions, and it takes hours and hours. And then finally they vote to confirm you. And we're finally now seeing some bunch of confirmations getting through. The Fcpa unit is pretty much fully staffed up now, both at the SEC and DOJ. So that is something to keep in mind, that just because it's been a little bit slow, it's not only a presidential transition, but we're also coming off of COVID. So there's a big backlog there. Things are definitely going to be ramping up. And the Biden administration on June 3rd announced their National Security Anti-Corruption Initiative. So it was a press release, it was a big event, and they announced that establishing a fight against corruption is a core U.S. national security interest. And they outlined a number of ways that they're going to do this, but it really does, shift the narrative back to the fact that the U.S. views Fcpa enforcement as a national security interest, and this is something that the Biden administration is going to make a priority, and this will definitely be one part of it. Additionally, there was a new law passed in January. So this is a little tricky. We have our giant annual, the National Defense Authorization Act that's passed every year, this huge military spending bill. But it's always going to get passed. So senators and congressmen will put other things in the bill that are not related at all to defense spending. So there was an anti-money laundering law hidden in this giant bill that is definitely going to facilitate and speed up the process of the US government being able to retrieve evidence abroad. So this new law provides certain government agencies, including DOJ, with a brand new power to subpoena foreign located bank records in any investigation under federal criminal law. And this is huge because in the past, prosecutors really had to heavily rely on diplomatic channels, such as MLAT requests, which take a really long time to proceed. And in the past also, authorities could only subpoena a foreign lender for financial records when there was a US correspondent account involved. But now, prosecutors can ask those foreign banks directly now for information on any accounts they have, including entirely foreign bank accounts. And this new subpoena power is going to allow a much quicker way to gain access to overseas evidence swiftly. And the chief of the Fcpa unit has said that she is going to likely be using this. I don't blame her. It's a lot easier than going through all the channels, but she did say that there are political concerns. You really have to pick and choose when you are going to use this, but on cases that they want to, I definitely think that this is a extremely powerful new tool that they have. And so overall, the US government has more tools in their toolbox right now. They're ramping up. We're expecting to see increased enforcement with the administration turnover, COVID, this new ability to just get the bank information without going through the regular channels. And so it is definitely something to keep in mind, that just because it's been a little bit quiet lately, this is likely going to be an area that we're going to see a lot of action going forward. So our
timing of the conference is right.
It is. It's perfect. I mean, I keep saying every time when we were talking about planning the conference, there would be a new case that came out every week. I mean, so I bet we'll get one this week. We'll see.
Nice. So, Kathleen, thanks. Having you here is a huge asset for us. Can you tell us a little bit about, the consequences of non-complying with FCPA, civil and maybe criminal liabilities? And also, in Turkish law, we don't have the same methodologies or mechanisms like in US law. Like self-cooperation is really so much important. Self-disclosure and cooperation is really important. Could you tell us a little bit about that, maybe from your experience?
Yes. So especially with the DOJ's new, the corporate compliance guidance, which you all have helpfully translated into Turkish, there's definitely a huge benefit to self-disclosing. And I mentioned earlier that Goldman Sachs case. Goldman Sachs discovered the bribery through an internal investigation, and through their outside counsel disclosed it, and as a result, they were not charged. That is a very, that's unique. It's very unique under U.S. law, and it's tricky because it's scary to think about just walking up to the federal government and saying, "Hey, we found out we this bad stuff happened under our watch," but you do get credit for disclosing it to the government, especially when it is a result of an internal investigation, and especially when you can come to them and say, "Hey, we discovered this. We fired the person. We hired a whole new compliance team, or we're building out our compliance team. We're revamping our training." Just the things that you can do to show that you are committed to as often many people call a culture of compliance, from the tone at the top all the way down. And again, it is scary to think it's much easier to sort of bury your head in the sand and think, all right, well, we found this, or this might be going on. We've got all these tips to the hotline like WPP did, and we're not going to check them out. But there actually really is a huge benefit to doing an internal investigation, bringing in outside counsel, and figuring out, do we need to disclose? What can we do so that when we do go to the government, we can say, hey, we found this. We know we made a mistake, or here's why we didn't find it until now, and here are the things that we've done to change. So, yes. And the criminal versus civil liability is
we already
kind of
in the white paper.
Yeah, it's covered in the white paper.
Yeah. Page 15, yeah.
Yes, so page 15, page 16.
Yep.
A good way when you're conducting compliance training for employees at a company, I've always found, is to remind them it's not just the corporate criminal liability. There's individual criminal liability, and you can go to prison and you have to pay your own money, depending on what your contract is. But that I've always found is a very good way to get people to pay attention when you're doing compliance training.
We start training with this.
Yes. Yeah. Exactly. Yeah, I've done that before too. I'm like, all right, listen up. And they're like, oh, but it's the corporation. You say, no, you could go to jail. So, yes.
Yep, thanks for all the valuable information. Now I'm giving the floor to Burcu to talk about third-party risk management more and, emerging markets highlights.
Thank you so much. I would like to thank my esteemed colleague, Kathleen, for her valuable contributions, and I would like to thank you all for being with us today, because just a year ago, my compliance journey started a year ago, and just last year, these times of the year, I was seeking out for some resources to learn compliance, but right now, just contributing to a resource means a lot to me. And I also want to thank Michael Robinson and Çetin Kaya for letting me to have this opportunity to contribute to this resource. Today, I'm going to talk about third-party risk management in terms of the Fcpa liability. But before just diving into the topic, I would like to explain what is a third party, who is a third party, whom does it cover. Any natural and legal persons such as suppliers, vendors, business partners, resellers, distributors, agents and consultants are in the scope of third parties. It is different from the well-intentioned third person just regulated under the Turkish law. It is a different concept. It's a totally different concept coming from Anglo-Saxon law. First party is the company itself, and the second party is the employee and their customers, and the third party is the consultants and the representatives, just vendors, suppliers, distributors. But why I'm liable from the actions of the third party? Because the Fcpa expressly prohibits and covers any payment made to any person while knowing that all or a portion of such payment or thing of value will be offered, given, or promised directly or indirectly to a foreign official to retain business or obtain any kind of benefit. But what do we mean by knowing that? There are just two possibilities. First, I might give the direct instruction to my third party to receive this payment to foreign government officials. Or second, I can make the payment while knowing that there is a possibility of this third party to receive this payment to a foreign government official. In the second one, there is a difference. I don't know it, but I don't want to, I close my eyes to not to see it. This is different. So we can say that I will be deemed as I know if I'm aware of the high potential of the third party's engagement and misconduct, and if I don't know, if I don't show due care to understand, to see, to choose my third party and to understand its potential to engage in misconduct. And this is quite similar with the vicarious liability regulated under Turkish law, the liability to show due care why I choose my third parties. So in Turkish law, if we go deeper, it's familiar with the liability of due care. So the Fcpa did not want to leave a blank space for head in the sand situation, for willful blindness, or in other terms, conscious disregard. So I'm liable with the actions of my third party, its misconduct, because I did not show due care to choose it, or I did not want to see it because I did not make the honest effort to control the risks. So the burden of proof is different, regulated different in here. It's on the shoulders of the main company. So there is a common misconception about distancing the company from the foreign government official through a third party would shield the responsibility of the of the main company, but this is not happening if we review the cases, as Kathleen mentioned. And in the Airbus case of 2020, the France-based global aircraft company alleged to engage in third-party business partners to pay bribes in China, and the Airbus agreed to pay combined $3.9 billion. And this case is ranked as the second in the top 10 Fcpa enforcement cases based on the penalties and disgorgement amounts. And if we refer to another case, it is Ericsson 2019. The Sweden-based multinational telecommunication company alleged to use third-party agents and consultants to bribe foreign government officials in Djibouti, in China, Vietnam, Indonesia, and Kuwait. The penalties agreed to pay is over $1 billion. And this case is also ranked as the 4th in the top 10 list of Fcpa enforcement. Actually, there is a really high statistic shows that if we review the 40 years all Fcpa enforcement cases, the enforcement cases linked with the use of third parties is 90%. This is a really, really high rate. And up until now, from 2018, all cases involve a link with third-party payments. So we are all aware of third-party risks, but what we can do and what is expected from us to deal with it. Is this really expected from us to mitigate the third-party risks, or we just let it go? Fcpa does not let us to do that. The Department of Justice evaluation of compliance programs just regulates that we need to control and manage third-party risks, and third-party risk management plan should be an essential part of our compliance program. Because they evaluate a compliance program's effectiveness through reviewing if it includes a third-party risk management plan, if it's comprehending the file of operations, the size of the company, the size of its transactions in different jurisdictions, in different locations. So they seek for some couple of matters that a risk management plan should cover. To start with, we can start with the risk assessment. This is not only a risk assessment regarding our third parties. We need to understand our capability to cope with these risks. I mean, if our third party is operating in some risky jurisdictions, we should have the opportunity, we should have the budget to control these risks. In scope of risk assessment, it is expected from companies to understand the business rationale to involve a third party in this transaction. Do I really need to use a third party in this transaction? Can I just provide it inside, or should I outsource it? And there should be a justifiable reason for this third party engagement. And we should understand the risks of involving a third party in this transaction. For example, if this transaction includes very, very close relations with foreign government officials, then we should stop and think that, what are my risks? Can I just conduct this transaction by myself? And we can just compare some different third parties to understand the interest for the company. And we should present a risk-reward balance, and we should choose the third party that is the best interest for our company, not the third parties that have a potential to pay bribe to foreign government officials. And another point that is essentially sought out in a third-party risk management plan is due diligence. It is not expected from all companies to conduct and enhance due diligence all the time. It should be risk-based, because they're global companies operating in different jurisdictions and they have billions of third parties. They should conduct this due diligence in a risk-based manner. For example, if the transaction includes government officials, or if it's conducted in a strictly regulated area such as energy or healthcare, maybe the due diligence can be enhanced. Another point is that due diligence is not just conducted once in a whole third-party relationship time. It is not a tick-the-box thing. You should repeat it after time to time, as long as your relationship goes on. For example, if in case of a change of control, what you can do, you need to repeat this due diligence again, because the third party that you know before is completely changed after the change of control. Sometimes the due diligence might not be possible before the contracting or onboarding, then you can have slighter one, and then you can conduct the due diligence as more comprehensive after the transaction. But you should have this provision in the contracting process. So as Kathleen mentioned, the case AMEC Foster Energy Limited, there is an important point in this case. Just conducting a due diligence and just defining the risks of third parties is not enough. You should integrate this process with your internal decision mechanisms. In that case, that AMEC Foster Energy Limited case, the one of the third parties alleged as paying these bribes to foreign officials was previously a third party failed in the due diligence, but the company just kept going on working with them. So that is why this case is also a little bit important.
So you say that it was detected by the company, but nevertheless they go along with this third party?
No,
okay.
They go on with it because maybe their profit was high.
But no compliance, no business. This is our motto.
Yes, of course. You should tell this to companies.
Sure.
And the another part that is totally seeked out in third-party risk management plan is the risk-based contract structuring. Why is that important? Because actually this is where you use the risks that you define. Okay, in the business world, everything is not going as the compliance says. Like, we just define the risks, we rate them, and then after rating them, if you decide to contract with a third party, you need what to do to take the necessary measures to control the risk, because all transactions have their own risks in terms of that transaction. So where you can manage and control them is where you contract. For example, if you provide your company with necessary provisions in contracting, then you know what to do when you see the red flags, when you see the alarms. For example, a very essential provision sought in contracts is the provision of assignment and subcontracting. Because you conduct a due diligence for your third party, you maybe separate a really high budget for this, but then your third party just assigns all its liabilities to a totally stranger that you don't know before, so your due diligence means nothing. So another important issue might be periodic reporting and right to audit. Sometimes periodic reporting is important because you want to have information about what is happening inside the third party. You want to know the situation about the performance of your contract, about the services, and you also want to know what is inside of your third party, any change of control, etc., insolvency. It may depend. And you should be sure that you have the right to audit your third party, because sometimes periodic audits are not enough. You see some red flags, you see some, I don't know, it really depends. But if the third party would not let you to make the audit, just make sure that you determine an independent audit firm for this. So termination is also important because we do not want to just stick with the contract even if red flags alarm us to terminate the contract. And that's why we usually do not advise automatic renewal clauses, because it holds the company for like additional time, and maybe it will be too late in the end if you know the red flags.
We are a little bit conscious about time, so we have 20 minutes.
Okay.
So if you can give us a little bit insight about emerging markets and maybe third-party risk management culture.
Okay. So just two more important parts of the contracting: some indemnification and penal clauses and compliance clause. And the last part of the third-party risk management plan is ongoing monitoring, to just watching what your third parties are going through. And so we talked a lot about third-party risk management, but we talked about the different risks that all third parties have. But we also talked about some jurisdictional differences and geographical location and market conditions related to risks. So step by step, we are getting closer to the emerging market case highlights. We can start with the definition of it. So what is an emerging market and why is that important for us? As just some couple of minutes ago, we mentioned that all third parties are not on the same risk levels. Some of them are in more risky situations due to their geographical location or the file of their operations. IMF World Economic Outlook classifies the emerging markets and developing markets as defining 39 advanced economies through their per capita income and or the export of diversified goods and services and their greater integration in global finance system. And all of the other economies can be classified as emerging market economies. Why is that important for Turkey? Because IMF also classifies Turkey as an emerging market, and Turkey has the 20th biggest economy in terms of the nominal gross domestic product. And when based on the GDP purchasing power parity, Turkey has the 11th biggest economy. So what are the similarities of these emerging markets? They have an ever-growing nature. They bring high opportunities to investors, like high income in a short time period because they are they have a dynamic nature. But there are also some similarities in a negative way too. As high they provide us with high return of income, they also have their own risks. Why do we address risks right now? Because the risks change our way of doing business in these countries. For example, their weak legal framework to prevent corruption, their absence of political will to fight with corruption, lack of transparency, existing corruption culture, and passive or non-existing enforcement bodies cause high risk of bribery and corruption in these areas. Transparency International's 2020 report of Corruption Perception Index ranks the countries from the ranked as most corrupt, and Turkey has the rank as the 86th. And what is similar for emerging markets in terms of this list is that first 20 countries as the least corrupt does not include any emerging market economies. But why do we touch upon all this information? Because this structure of emerging markets, its abusive environment also causes a tendency of investors to engage in misconduct in these countries. There is a misconception of that. There is no anti-corruption law, there is no cross-border, there is no regulation that has cross-border enforcement such as the Fcpa, so I can engage in misconduct in these jurisdictions, but this is not true, as we see in the cases. In the top 10 list of the Fcpa enforcement cases, we see that there is an emerging market involvement. And also, we can touch upon some of these cases. For example, as Kathleen mentioned, the Goldman Sachs case, there was also an involvement of alleged payments of bribes in Malaysia and United Arab Emirates. Also in the cases of Petrobras, Telia, MTS, Siemens, Alstom, Wimpel, all involve alleged payments in emerging markets. And also, Kathleen mentioned the case of WPP, so I will not just dive into it, but this was also in relation with the alleged payments made in India, China, Brazil, and Peru. And for the last case, in Alexion Pharmaceutical case, it also included alleged payments of bribes in Turkey, in Russia, Brazil, and Colombia. This is why this case is also important. And even up until now, there are only 7 cases with Turkey involvement of all times FCPA enforcement cases. The similarities that Turkish market shows with other emerging markets tells us that we should be careful about these similar risks, and we need to take some notes and learn some lessons from the other similar cases involve emerging market bribery. And what else I can say, that all these named cases they were in relation with deep-rooted and well-known global high reputational companies. So, but it turned out to be that, so we can say that their compliance programs, even they thought that they have a really nice one, did not consider the challenges that emerging markets have. And I would like to leave the mic for my esteemed colleague, Altubey, because right now, after that part, I would like to highlight the importance of a risk-based compliance program that should consider the challenges of emerging markets. So in compliance programs, we can touch upon this.
Thanks, Burcu. So it's really difficult to speak in between these spectacular experts. So we were going to mention about compliance programs, because compliance is at the heart of what we do and the business, and we want to be more proactive and preventative in terms of legal thinking and methodology. Because in the past, in Turkey, we always think that lawyer is a go-to person when some incident happens. But we need to change this strategy. We need to be more prepared. And as Kathleen said, compliance programs are a mitigating factor for FCPA enforcement, right?
Yes.
Yeah.
Very big.
Okay. So I'm relieved. In our white paper, you can see more information in page 25. But what I want to give more reference to is the United States Department of Justice guidelines for evaluation of corporate compliance programs, which we had the privilege to translate it to Turkish with my esteemed colleagues, and Ethics and Reputation Society has issued that and published that. And I'm seeing Fikret here. We also had a white paper with him before about Alexion case as well. So we are developing our knowledge and know-how, and we have the privilege of our U.S. experts here. So in U.S. DOJ guideline, actually there are 3 questions to be addressed for a best practice effective compliance program. So these are actually addressed to United States prosecutors for guiding them on determining the effectiveness of compliance program and whether they can use it as a mitigating factor on their enforcement in the cases. But we can actually benchmark these questions and ask these questions to ourselves, whether we have a good compliance program in place, whether we can improve that, or if we are starting from scratch, which are the right questions to ask. So these are, we can maybe sum up into 3. So is the program well designed? So as Winston Churchill said, failing to plan is planning to fail. So actually, first we need to, before making a tick the box approach here, or just copying and pasting, a good sexy-looking compliance program, we need to ask ourselves what is the target here? What we want to achieve? Do we want just a compliance program sitting in the corner and without an effectiveness, or do we want to build the ethical culture within the company? Do we want to attract investors? Do we want to attract new talents within the company? Or do we just want to be legally safe? Because we know that ethics and compliance is not about just obeying the law. It's going beyond the law and thinking outside the box, that, thinking about the future, because, what we say legal can be illegal in 20 or 30 years. So we all seen that. So the second question is actually, is the program applied in good faith? Good faith, we all know it from our civil code, or deeds and actions and contracts should be in good faith. But what is actually meant here? So from my interpretation, the authorities say that, if you want to apply a compliance program, you need to take responsibility and you need to apply in good faith, which means you need to be sincere in your actions and words. You need to invest into that. You need to have resources about compliance. Employing a compliance director is not enough. You need to provide the right budget for it. You need to inform the employees. And more importantly, there is a misconception about compliance programs that people think that it's just the business of the compliance department or the legal department or internal audit. But we want to expand it to all the employees, and we want to give the ownership. That's how we can define the ethical culture within the company. And we are all stressing this ethical culture because we want to also give the multidisciplinary approach to compliance. It's not only related to finance, it's not related to legal, but psychology too. Sociology, human management, business awareness should also be there. So we are saying, I'm getting questions from young people that, do I need to be a lawyer to perform compliance, or can I be a compliance officer if I'm not a lawyer? So you can maybe answer that, but from my interpretation, we want a mixed team when we are developing a compliance department. We can have a law background people, but we can also benefit from somebody from a business perspective or human resources or management perspective. What do you think?
I completely agree. I think I said it before. You'll see this in a lot of the U.S. Companies use this, again, the tone at the top or culture of compliance. And it is really important that it's not just the legal department. Everyone likes to always, make fun of the lawyers. They're the ones telling me no and making me sit through all these trainings. But when you give responsibility, like you said, to HR and to the business development folks that are the ones who are actually really managing those third-party contractors that are out there on the ground, whether it's distributors, vendors, marketing, ad agencies, things like that, you give everyone ownership. And that is ultimately what constitutes, I think, is the program applied in good faith. You mentioned HR. I cited that one case, the WPP again, where, okay, we had a compliance program set up. We had this anonymous inbox, hotline type thing. But if HR or whoever, if HR is not working with legal to monitor those calls and they just go and they go unanswered, that's not a program that's applied in good faith. And you can't just leave it up to the legal or the compliance department. It does really need to be everyone, and not just for Fcpa, but for, like you said, all different types of, for the laws of every country where you're doing business. And
not for Fcpa, but exactly when as a Turkish lawyer, when I see the methodology of Fcpa and all the supporting documents, we find that this is the go-to law, go-to legislation when developing a compliance program, because it's been around since 1977, and we have the methodology, and we have benchmark cases here. So we can apply the same principles if we want to develop a competition compliance program, or a data privacy compliance program, or ESG compliance program. I don't know, but
Sanctions,
export,
sure, everything. Sure. I mean, even HR type programs like employee relations and investigations on that side. You're exactly right. It really is so comprehensive that it is a good base. You know, again, it's bribery and corruption.
So we are lacking out of time, and my colleagues stares at me anxiously. So I will not go into detail, but you know, the elements of an effective compliance program, the policies and procedures, tone at the top, tune from the middle, is also needed, because in the past we were always discussing about tone at the top from the top managers' commitment, but right now we are also we want to also you know, expand this to middle managers as well. Risk assessment is a, you know, inevitable element of a compliance program. The best risk assessment is the one best done with the business people. So it's also a misconception. It's not the job of the compliance officer or the legal or finance professionals. Another aspect I want to mention and close is speak-up culture. So especially the territory, eastern territories like the Turkey and the neighboring countries, we can have a closed disclosing system, you know, according to our culture. But Fcpa and other extraterritorial laws actually encourage us to speak up even when we are in doubt, and it also obliges the companies to set up whistleblower protection programs as well, where you can actually report your concern anonymously, and also non-retaliation is another aspect of a great speak-up culture and hotline program. So you are here to protect also the employees for a potential retaliation because they are speaking up. So we can conclude here, and we can get some questions from the audience, and then we can have a short break. Yeah, please, Sarpe.
First of all, thank you for all this valuable information. My question is, what is the clear difference between being intermediary or lobbying for?
The difference between lobbying and...
Yeah, for example, for the Ghana cases, the individual, okay, he's paid by Goldman Sachs, he's an employee, but what is the difference? Perhaps, yeah, he can say that I'm lobbying because I know that lobbying is very common in US.
Yes.
So how we can, yeah, how the authorities says that this is not a lobbying, this is a being intermediary. Thank you.
That's a very good question. It's one that I think about a lot, actually. Some people like to say that lobbying is basically like legalized bribery, but the difference is that in the U.S., you know, when you're lobbying, you are a registered lobbyist. That's a whole nother regulated industry, but when you're lobbying, you are, again, you're registered. You're also not like with the Goldman Sachs case, you are not paying, you know, you're not paying a bribe to get a contract. Lobbying is usually often just meetings. You're getting meetings with government officials. You're not promising that you can do anything for them. It is a fine line. Again, it is hard. It's a hard one to defend, but the best that I can really offer is that when you're lobbying, if you're lobbying at least in the U.S. And there's a whole nother law, the Foreign Agents Registration Act, FARA. That's a big one. But that's a whole regulated industry, and there are rules as to what government officials can and can't accept. That also speaks to the emerging markets problem. There are not rules in a lot of in emerging markets that restrict what types of gifts can and cannot be received. So that's another part of the risk assessment. But again, it is a very good question, but it comes down again, I think, to those five, are those five FCPA elements there? That's the bribe. Like, is there a payment? Is it, are you trying to get something done? Is it going directly to them? It's different than just a meeting.
Okay, do we have any other questions? Okay, Umut, please.
Thank you.
Thank you.
So, that was a great analogy. So, having these long arm, right, of the US. So when we say, as far as I know, yes, this is long arm extraterritorial enforcement, but the execution is only in the US territory, right? So, for example, the individual is executed only when he is in the US, right? So, or is there the US government is having any collaboration with any other governments? For example, if this is a Turkish guy and he violated an FCPA, he will be executed in Turkey for any penalty or not? This is one question. Or he should go to the US to go to the prison, for example. This is one. And second one, this individual liability, when we say individual liability, for example, let's say I'm banned for violating, and I'm penalized for violating the FCPA. In the future, for example, shall I work for any company who is responsible, who is liable for the FCPA or not, for example, in another listed company? So, thank you.
Great questions. Thank
yes. You. Okay, so
the first one is if like a Turkish individual is penalized, imprisoned, so will it be effective when he enters the US territory?
That's tricky. That could be a tricky one sometimes. That gets into the whole, the DOJ will give people, in order to get them to cooperate, something that's called a queen for a day. Essentially, you're allowed to travel to the US and they're not going to arrest you. Yeah, but...
So the DOJ is using its collateral relations with the other
authorities.
Oh, yes.
Cooperation.
Yes, exactly. And I mentioned that with the new law where they can just get the financial information, but a lot of this is done through diplomatic channels and governments working with one another, and there have been extraditions before in the individual
extradition
cases.
laws. We need to see extradition laws.
Yes.
Because it's also part of a legal discussion, but also a political part of it. But eventually, please correct me if I'm wrong. I'm sure that if there is a ruling in place, so the person will be confiscated in the United States when he or she enters that territory. So you are right with that comment.
And there is actually right now a case that is there was a guilty plea. The sentence is scheduled for January 2022. This is an individual that has been allowed to remain in the UK until he's sentenced. So he pled guilty. So that again is most definitely the US government working with the UK government to resolve these allegations, which actually involved emerging markets. It was Nigeria, Congo, and Venezuela. So yes, the U.S. government is often cooperating and working with other governments when they're investigating this. There's political aspects involved and diplomatic. It can vary.
You had a second question?
I mean, so this person, let's say, so is penalized. So this person is allowed to work for another there any system checking for it before hiring?
That's a good question. Yeah, I guess background checks. I would assume that when you just Google the person's name, that it often would come up. It'll come up in background checks, but it's not like there is a sanctions list, a sanctions list, an OFAC list where you can look at who's been arrested. This would be more subject to your typical internet Google search background
Or corporate
check.
intelligence.
Yes, exactly.
Yeah. So there is nothing official or mandatory, but the companies can have a discretion for not employing that.
Yes,
Yeah.
it's probably very hard to get hired again after after being convicted of Fcpa violations.
Okay. Do we have other questions from the audience? So if not, we will gonna have a short break for 30 minutes. Then after that, we will have a very nice session by our experts, Bentley, Brad, and Mehmet. They will talk about external and internal investigations. So thanks for listening.
Thank you.
All right, so again, I don't want to make too long of an introduction. I'll briefly introduce myself. My name is Mehmet Baysan. I'm a partner at Michaelman & Robinson. I guess it's self-revealing, but I am a co-chair of the International Arbitration and Cross-Border Litigation Department. We work closely with Chetinka and also with my partner Brad here on issues ranging from Fcpa to compliance, to cross-border litigation, federal litigation, arbitrations. We do all the interesting stuff, I have to say. We're pleased to be here. So the second session, the first session was obviously dense. It was very informational. I think our colleagues did a wonderful job of explaining where we stand today on the Fcpa front. It's a very complex law. It has an extraterritorial application, so it really is applicable to all of us, and it's important that we know about it, and so we can protect our companies, respective companies, and some of the executives who are at the front lines of our companies. Today we're going to talk about, and I will probably be moderating more than talking. I can't promise, because once I start talking, I can't stop. That's one of those things. Just comes with my trial lawyer training. But I will be moderating more than I'll be speaking, and we'll be talking mainly about white-collar internal investigations, how these things play out in real life for people, individuals, and for companies as well. We got Bentley here. He's obviously a Turkish lawyer who knows Turkish law. I don't know anything about Turkish law, and hopefully he's going to help us understand how this American law, Fcpa, finds resonance in Turkish law, and how it parallels and how it differentiates, how it plays together, all the things that I think we all need to know, especially when we're doing cross-border transactions. So I'll start. Well, my section is management of external investigations. So basically, usually we as counsel, we get a call from the in-house saying, we got a subpoena, we got some questions, somebody called us, we saw our names on the news, things are going on, we need to address a couple of things. We obviously, as external counsel, usually ask a lot of questions. And an in-house counsel sitting in that position should be asking those questions before we ask those questions. So they sit in an extremely important spot. And we basically reflect upon their own information to understand what's going on, to do the things that we can do to mitigate damages. Altu said earlier today, obviously, compliance is mitigation. So did Kathleen. We want to do this as a preventative measure, not so much as a measure to attack or respond or address a concern that has been raised by one of the regulators in the United States or elsewhere. So we, as external counsel, usually would like to know more from the in-house counsel. So if I'm the in-house counsel sitting in, which I've never been an in-house counsel, I would probably want to know all the facts before I call the external counsel. And of course, I want to make the call right away so that we can start working on things to mitigate damage. But Brad, it's interesting from your perspective. Obviously, you've helped a lot of companies to, and also individuals who've been in this situation. It's a difficult position to be in, to say the least. So, how does this go about, and what do you do?
Yeah, so Mehmet said it, right, that investigations come up in a lot of scenarios. We've had them where a client has gotten a copy of a PowerPoint presentation from a government agency that was talking about them. As many of you know, I know there are a lot of compliance professionals here and in-house counsel. So I'm certain that you all are very familiar with how these things pop up their ugly head. And in an FCPA context, it's a well-known fact, right? 90% of FCPA cases, if you're following trends, come from third-party suppliers who have been reported or something has happened as part of the anonymous tip line, right? It's you get a call on your tip line, so-and-so has been paying bribes, so-and-so has been receiving bribes, we got a contract because there were illegal payments, we have accounting control issues. And then what do you do about that, right? And I think what we're going to try to do today is talk about, me as I have my attorney hat on as external counsel, and then you put your general counsel hat on and you say, well, what do I do when these things pop up? Investigations are very simple, right? An investigation is really just fact-finding. I think a lot of companies, not only in Turkey, I've represented, lots of companies in Turkey, but I've also represented lots of companies in other countries, but also in the U.S., right? If you've never been through an internal investigation, it sounds like a scary thing. It's not. And there are lots of reasons why you might want to do an internal investigation using outside counsel, but Mehmet said it, right? Before you have to make that call, there are some things that you can do in-house to try to figure out what the issue is, right? And if you get an anonymous tip and you say, what do I do about this? You can do some initial fact-finding. You can ask some questions. But the most important thing you have to keep in mind is you can't, unless you are set up ahead of time with policies and internal procedures to do an internal investigation, you're going to want to call counsel really soon. And the reasons, there are essentially 5 of them, right? Privilege, number 1, right? Privilege is the most important thing. Now, when I go into an investigation, I tell clients, right, we're going to investigate, we're going to look into these issues, and we're going to keep in the back of our mind the whole time that at some point in time, it may be beneficial to us to go to the government and say, here's what we found, right? And we'll talk about all the reasons why, but the bottom line is you can, in some instances, completely avoid penalties altogether, even if you find wrongdoing, which is something under U.S. law that's very unique and something that they've been pushing over the last few years that's extremely important to keep in mind. The other issue, and Bentley will talk about this a fair amount a little bit later, is privacy, right? There are privacy concerns when you do an investigation for your employees and the executives and the people that are involved, and so you want to make sure that you're not stepping on a privacy landmine. The third thing you have to keep in mind that's important is data preservation and collection. An investigation turns on your ability to gather information and analyze it, right? So we as external counsel often, if we get a call, the very first thing that we're going to do is say we're going to issue a preservation notice and say to all your employees and executives and the IT people, don't delete emails, don't get rid of documents, keep everything just like it is. We have to do it.
May I ask why?
Look through. Why? Yeah, so the real answer is because at the end of all of this, if you do end up going to DOJ or the SEC or CFTC and say, I've done this internal investigation, and you have to tell them what happened, they're going to ask you, well, how did you do it, right? Because they want to make sure that the investigation was independent, right? That you have credibility, and that you are giving them everything, and it's not, we came in and we looked in this little spot, but we saw things that existed outside of that wrongdoing, like there were bribes here, but we had information that other bribes happened, and we didn't have the data to go and dig into that, they're going to ding you for it, right? You're going to get in more trouble because of that. The two other things you got to sort of consider in internal investigation when you're thinking about, do I need outside counsel, is who is going to be in control of the investigation? Meaning, is the board going to be in control? Are you going to appoint an independent investigative committee who can do it? Often that's a good idea if there is wrongdoing or the belief that there was an executive that was involved in wrongdoing. Who is outside counsel going to report to? We spend a lot of time at the very beginning talking about, well, who is it that we're going to give all this information to when we find it, and how are we going to report it, which is the fifth thing, is coming up with reporting structure. And if you haven't been through an investigation before, all that sounds like a bunch of scary stuff, and it sounds daunting, and it sounds like it's going to cost a lot of money, and all those things you have to consider as in-house counsel or compliance professional. But in reality, it's not necessarily a scary thing, right? It's something that the U.S. particularly has put into place rules that benefit you. You get a reward for doing those things, essentially at the end. And the cost of doing an investigation and setting up a compliance program that Altu talked about are so much smaller than the penalties that happen if you were caught and you go through the process sort of after the fact and don't take a proactive approach.
Can I ask a question, Brad?
Yep.
So I'm an in-house counsel, and I'm thinking, okay, I'm going to call my external counsel, and you said privilege, right?
Mm-hmm.
What do you mean by that? Because that can be very challenging to understand what privilege and attorney work product and those types of words that we throw around, but for an in-house counsel, it can be actually a bit challenging to understand what's going on. So can you perhaps just touch upon that a little bit?
Sure. So under U.S. law, there are a number of privileges that control an investigation. One's the attorney-client privilege, right? I'm the attorney, the company is my client, anything the company tells me in anticipation of litigation or in furtherance of seeking legal advice is privileged. In the U.S., that's sacrosanct. It cannot be violated. The issue is in those investigations, right, you have to define the client specifically. Because if we are reporting, for instance, to the board of directors, but the board of directors is taking that information and pushing it out to a third party, right, even if they are within the company, you can waive that privilege, right, which causes a few things. One is the government can prematurely put their hands on the information you're collecting, right, before you are ready to go to them and you have a strategy in place and you talk about all the pros and cons and make that decision. The other thing is if they're in Fcpa violations, particularly if there's issuers involved and there's a collateral civil litigation or other regulatory action that occurs, right, the person suing can subpoena that information. And if you get into a privilege fight, then you may have to give up information that otherwise would be confidential that could be very damaging. The other privilege that we work with a lot is the work product privilege. That's really a privilege to the attorney. The attorney-client privilege belongs to you, to the client, to the company, or to the person. You choose whether you waive it or not. We do not get to make that choice. The work product privilege, however, really has two layers. One is opinion work product. The other is fact work product. So, for instance, facts in a case, right? What happened on a day, business records, bank accounts. Those are not privileged items, right? The government, through many processes, including subpoenas and MLATs and those things, can go and find that information. But if I'm an attorney and I'm writing down, I'm interviewing one of you and you tell me some things that happened and I'm writing them on my piece of paper, and I am putting my opinions down about what I think about what you're saying and how that applies to the other things that I've seen, that's privileged. That can't go anywhere. And the U.S. is very good about protecting opinion work product. Now, that second layer I talked about, fact work product, which is you are telling me a fact and I am writing it verbatim on my piece of paper. That is not protected as carefully as opinion work product. And so we as outside counsel think very hard about when we take notes. You know, we put disclaimers all over it. This is not a verbatim transcript of the discussion that we had. These are my opinions, yada, yada, yada. And we'll put in there, right, on every page, attorney opinion, attorney opinion, attorney opinion. So those privileges are important to you because it allows us to keep the information within the circle of trust, right, until we make the decision to give it to someone else. And you do that for myriad reasons.
So these interviews that you were talking about, right, some of the fact finding, do you think that should be done by external counsel, or is in-house I should be doing those things?
Absolutely. It should be done by interviewing is a very important thing. And it's important at a lot of levels, right? Very basically, even sequencing of interviews. And when you conduct an interview is an important thing that you've got to keep in mind, right? Because you may want to interview people that didn't have a lot to, you interview your IT people, you interview your HR people, people in the beginning to just get up to speed and understand how the business works, who the players are. And then as you go, you make decisions about, do we interview the people who are actually involved? Are we going to treat them as a friendly interview? Or are we going to go in and try to get admissions out of them, an admission interview? How do you approach that? Very often I recommend to clients that, you know, we wait on interviews until we do the data preservation and collection and start to read emails and start to look at internal communications, because then you get a lot of stuff that you need to ask about that you may otherwise not know that you should be asking.
Yeah, please.
So jump in just to add to what Brad was saying, and I'll discuss it a bit more in detail when I'm talking about Turkey, but I'm sure you have a similar experience too in terms of when you install external counsel for the interview process, in that you also have to be mindful of other areas of compliance as well. I mean, labor law is one area, sort of privacy and data protection is another one as well. So when you situate someone externally, in our experience in terms of investigations carried out in Turkey, then it's also both in terms of the information that we're able to glean from the interview subjects, in terms of documentation, in terms of protecting the company against any future accusations or actions in terms of sort of mobbing or coercion, had these investigations been carried out internally by a source within the company. These are all things that we have to be mindful of, because as Brad was saying, the internal investigation process is obviously a means to an end in terms of the report that comes out in the documentation, and making sure that documentation then can be the basis of a successful compliance action or reporting action is important to make sure that the content and the information itself can't be challenged in any other way. So so from our perspective too, sort of situating external counsel as a clear point of contact there that's facilitating or organizing the interviews is always important.
I mean, to that point too, a question for you, Bentley. We talked about privacy earlier, but when you get into investigation and use external counsel, right? I mean, for example, in Turkey, because we're talking about how Fcpa affects Turkey and investigations. You know, if we're coming in and we're working with you, right? We say, hey, Bentley, we're doing this investigation. We're getting ramped up. You know, I need to ask questions to employees. I need to collect information, right? I need to get their emails. Right, you got if you were doing it in Europe, right? You obviously have GDPR concerns. If you're doing it in the U.S., you have like the California Privacy Rights Act, right? And those kinds of things that you sort of have to consider. How does outside counsel help you navigate those things?
I mean, anyone in the audience who's been dealing with the Turkish data protection law knows that particularly transfer of information abroad is its own minefield at the moment because of the lack of clarity in terms of what type of information, or first of all, what legal grounds you can rely upon for any international transfer. So Alto and myself have recently encountered these situations where we have either been assisting yourselves or other external law firms abroad, or the parent companies of clients who are located outside of Turkey. And in terms of accessing the emails, it's at the moment, due to the current situation of cross-border data transfer and what grounds you can rely upon, it's a balance of risks at the moment. In terms of, obviously, the most lawful way to carry it out in Turkey is by obtaining explicit consent, but that undermines the very nature of a confidential internal investigation for compliance purposes. And then there's a number of other lawful bases for cross-border transfer from Turkey at the moment, but none of them are practically applicable for this investigation process because it's in a way revealing the investigation process. So it's a balance of risks. It's shifting maybe the initial analysis, the keyword search of such information to local counsel in Turkey, and then it's maybe sharing some more general findings with sort of any expert foreign counsel, or if it's a multinational company that we're talking about, it's looking at documentation that they already have in place with their employees, any sort of previous warning that they've provided employees, or any previous documentation provided to their employees when they started work, in terms of what information or what personal data could be accessed, and what rules they put in place for cross-border data transfer. So it's very much a case-by-case analysis, and then it's looking at, obviously there is an inherent data protection risk if no prior action has been taken, which is again links back to what Alto says in terms of a robust compliance program is important, and not only from sort of the Fcpa perspective. It's looking at all the potential data streams and information streams that can feed into this program, and making sure that as a company or as an entity, that all of these other considerations are taken into account, and either consent is obtained or proper documentation is provided. If a time comes when, as you said, like a client, if a general counsel rings up and says, we're in the news, we need help, then at least we have a clearly defined procedure or a clearer basis for risk assessment in order to determine what information can be transferred.
And one of those things that I nitpick, and if one of my co-counsels hearing me, probably he'd be laughing by now, but credibility is a big thing in the United States. We deal with regulators all the time. We deal with courts, judges, prosecutors, opposing counsel in many instances all the time. And we as external counsel need to preserve our credibility. What does that mean? It means that the information that we're getting from you needs to be reliable. The in-house counsel needs to be working with us to educate us with respect to what's going on, not hide information, because it's customary that we see once in every while that the clients get worried and information sometimes doesn't come easy, right? That really hurts our credibility and our chances of protecting the client, being the company itself. So credibility, I think, is something that you touched upon, and I can't emphasize this enough, that it really is important. And I know sometimes it really angers clients, because what does it mean? You're defending us, you're protecting us. What do you mean that you're hurting your credibility? That's why credibility is extremely important, and that's why in-house is positioned to help the external counsel to get accurate information as fast as possible and as accurate as possible is extremely crucial to make sure that we're doing our jobs properly.
But I was...
Go ahead.
I agree, but I also, from my
I promise I'm not going to speak that much.
But I think from the other perspective, it's obviously the information from the general counsel is important, but investigations that we've been involved in or have experienced is also as important obviously as external consultants, for us to, as soon as the initial strategizing, in fact, maybe not even when the fact finding is finished, going in and working with the general counsel to clearly determine and define what sources of information can be tapped, because that feeds into credibility too. As the fruit of the poisonous tree is also poisonous. So in order to determine what information can be accessed, what sources they can be accessed from, responsibility also falls upon external counsel to help guide internal counsel or internal teams to make sure that the information is being accessed from. And this is not only from a privacy standard, it's also just from any unauthorized access or any other third-party access, just to make sure that any information obtained is properly obtained and documented. Because the credibility issue is obviously, once this report is prepared and presented as the basis of any action, then challenges from credibility is going to come from opposing counsel, it's going to come from individuals named in the report. So it's just to make sure that everything is documented and all of the correct information sources are tapped.
So it's basically teamwork.
Yep.
External counsel, internal counsel, all the elements need to work together on this. So my U.S. counsel, my Turkish counsel, how does this thing work? What do you expect from in-house counsel, and how can you explain to us what good teamwork looks like to you, both?
My experience has been that when dealing with in-house counsel, right, it really is about communication. and there has to be a level of trust. Now, admittedly, I've been in a lot of situations, in fact, almost every situation, right? You walk into a room for the first time, a company is considering doing an external investigation. They've brought in external counsel to speak with them about it. They're interviewing firms to choose who they want to do it. At the end of the day, it comes down to trust, but trust is built over time. And what I would suggest to everybody here today is, if you're an in-house counsel or compliance in a compliance function at a company that has FCPA risk, that a internal investigation protocol and policies and procedures is the hallmark of a good compliance program. And so talking about those things ahead of time, right? Going in and saying, if I am running a compliance program, and if I am a company that's an issuer or a domestic concern or touches the U.S. Market in any way, and we'll talk in just a little bit about sort of the contours of anti-bribery versus the broader anti-corruption sort of regulation in the U.S., that you take proactive steps as part of your compliance program that you already have in place. And if you don't have a compliance program, obviously you should think about getting one, is getting ahead of the investigation curve, right? Sit down with counsel and say, I have a compliance program, but I don't really have an internal protocol for what happens when something pops up, right? I am planning for a worst case scenario. And if it pops up, like, what is my strategy to engage outside counsel? What can I expect for them when I get here, so that it's not a surprise to you when we walk into the door with a list of 150 things that have to happen in the next 3 weeks, particularly an FCPA investigation, where it may not only involve Turkey but other jurisdictions in the UK Bribery Act and other regulators and so on and so forth. Get educated about it, right? And all that costs you nothing, right? It's nothing for you to call Bentley or me or whoever else and say, what do I do when an investigation pops up? How do I handle it? What are my procedures or protocols? Like, what can I expect? How much money is it going to cost me? What is the outcome going to be? And we're happy to talk to you about those things. It's important to plan ahead. But I tell general counsel when we first go in is, I'm going to spend a lot of time with you. We are going to talk a lot. I'm going to be here. I'm going to come and spend time in your office. You're going to teach me about how your company works. I'm going to look at your documents. You're going to help me figure out where in those documents I need to be looking. We're going to employ document review programs and AI and things that are going to help you control cost. And we're going to have a conversation about those things ahead of time. So, it's setting expectation, having communication, and those two things help you meet that expectation. And I think those are the, sort of the basic principles of, getting to an end result that is beneficial to the company and beneficial to you as executives and compliance professionals at your company. Because at the end of the day, right, it is a little bit on you, because then you're going to have to report to the board or whoever it is that's running it and saying, I went out, I did my diligence. We can benchmark, at the end result, right? Was this a good result or not? And, talk through, how do you measure the value of that investigation? And you can do some of that ahead of time, right? We have stacks and stacks on, trends and what the breaking down the FCPA findings and rulings to try to figure out, what is DOJ thinking, what is SEC thinking, CFTC, now that they've dipped their little toe into it, what are they doing on that front? So I think it's a lot of those things mixed together.
So,
I mean, it's hard to disagree with that. Trust and openness is obviously the most important aspects when you're going into an internal investigation. Another important aspect that I would add was line of reporting or clarity reporting, which Brad touched upon when he was talking about the 5 major points, particularly if it's a company undergoing an internal investigation for the first time. establishing clarity of reporting in terms of what the information flow to external counsel is going to be, and also what the reporting structure inside of the company is going to be. And that's obviously important because when you have external counsel to make sort of cost more efficient, to make workload more efficient, we're obviously looking to streamline information. So having that information being reported and having that agreed at the beginning of the internal investigation process, what sources are we going to be collecting information from or going to be reported to us as external counsel. But it's also very important from another aspect of internal investigations, which is the confidentiality aspect, which obviously has to be maintained throughout the process. Otherwise, it sort of undermines the very existence of the internal investigation. So making sure that the clear chains of reporting and information gathering is defined from the very beginning, that whoever's responsible, whether it's the compliance professional, whether it's internal counsel, are aware of their position, are willing to accept this responsibility, because that's another pitfall that we occasionally see, is responsibility trying to be delegated to other people, and that may be sort of undermining the flow of information coming to external counsel, or meaning that parties within the investigated company that should not at that point be aware of the internal investigation becomes aware, and again undermines the very point of the internal investigation. So a willingness both to accept, openness and trust, but also a willingness to accept that position and placement that they are within the company and that they are the primary source of filtering information to and from.
I think I touched on this a little bit. Maybe one thing I think it's important to talk about, right? Because I know many of you here know Fcpa, right? It's the building blocks of Fcpa are somewhat well known, particularly if you're in a compliance function or your general counsel. That's something that your company deals with sort of day to day. But under U.S. law, right, there is an important aspect, and I said this earlier, which is, there is Fcpa, right, which encompasses anti-bribery and accounting controls and everything that falls under accounting controls. But there's anti-corruption generally, right, and that is sort of from a global context, but even in the U.S. And it's an important thing to remember because as we sit here today, and Kathleen touched on this earlier, the United States has made anti-corruption a priority. They have named it their top national security initiative, and that comes along with a lot of things, right? One of those is intergovernmental cooperation, right? So we are going to see, looking ahead, DOJ, SEC, and to some extent the CFTC coordinating much more carefully. Historically, they kind of did their own thing and met in the middle way down the road. There is going to be a lot of investigation now that they are going to coordinate on from the very beginning. They are going to be thinking about, and we've seen this, right? There is, sort of a two-track thing, right? Which is they report the corporate settlements, right? Which involve monetary penalty and monitorships and all the, sort of the hallmarks of a FCPA, DPA. But you see many more prosecutions, right, of individuals. And that's a result of what we call in the U.S. the Yates memo. Sally Yates, who was the Attorney General for a very short period of time, and before that the Assistant Attorney General, came out with a memo a number of years ago that said it is going to be policy in the United States that if you are a company under investigation, we are going to expect you to report to us the individuals who caused the violation, right? And that is the law of the land of the U.S. as it stands. And it's important because when you think about the FCPA, we all know in 1998 they amended the FCPA to include being able to charge foreign people who were acting in the U.S., right? And then there was like this flurry of cases, the Hoskins case, where they charged, I think he was a UK individual with a French company for bribery, happening in a foreign place. They tried to bring him into the umbrella under a conspiracy law, right? Saying that because there was an agreement between him and a U.S. person, that he individually could be prosecuted. the Second Circuit, where I sit in New York, said you can't do that, right? I can't charge that person with conspiracy because he's in a foreign place, and there's a thing called the Jabardi principle, which is basically if Congress doesn't say that they intended something, you can't write it into the law, right? So what Congress said in the Fcpa very specifically is we don't intend this to be charge foreign individuals. This is a U.S. law to touch U.S. action in foreign places. But as DOJ and the SEC will do, they didn't like that, and so they've tried continually to expand that. And so what we've heard in the last few days or weeks is that under the AMLA 2020, which is the new anti-money laundering law that was enacted under the NDAA in the U.S., that the U.S. government is, in fact, going to start issuing subpoenas to foreign banks and foreign people to get information that otherwise they would have had to go through a political procedure to go through the State Department. The other thing that they're going to do is that they are going to attempt to come up with other theories to charge individuals with FCPA violations. And what that means for companies is if they can reach out and charge the individual and bring them into a conspiracy, that person is the agent of that company, and therefore they can bring the company in as well. The ultimate goal, right, just like it is in sanctions cases and just like it is in other extraterritorial laws, is that the DOJ and the SEC want to expand the reach of U.S. jurisdiction as broadly as they can expand it so they can regulate conduct around the world, even for foreign individuals and foreign companies doing foreign business. And part of that dichotomy is you've got this Hoskins case saying you can't charge conspiracy, right? But the Hoskins case is still happening because what they did instead is they said, well, okay, fine, we can't charge conspiracy, but we can charge you as an agent of a U.S. company because you were acting on their behalf, right? Third-party liability. And the other thing we can do is we can charge you with money laundering because those downstream transactions eventually in U.S. dollars made their way back to the U.S. and they say, okay, well, we can't get you for FCPA, but we can get you for money laundering. There's an interesting case. It was the daughter of, I think it was the Uzbek president, totally foreign person, totally foreign business, was having foreign companies bribe telecoms, and she just put tons of cash in her pocket, right? And so the U.S. got smart about that and said, well, we're going to charge those foreign companies for the bribery, the anti-bribery stuff. We can't touch her because it's, she's this foreign person. We can't charge her with FCPA. But what we're going to do is we're going to seize all her money, right? So they went around the world and they froze all her accounts. And so that was sort of a double whammy. The other thing DOJ and SEC have both said, DOJ in particular, have said very specifically, is they are going to challenge the Hoskins case. There is a Seventh Circuit ruling that came out the opposite way. And so what happens in the U.S. system is different courts around the country make rulings, they're different, and they filter their way up until they get to the Supreme Court. And I imagine in the next few years we'll see a fight about how far can the U.S. use their conspiracy law to rope in completely foreign actors. The other thing to keep in mind too is that restriction on that jurisdictional restriction, right? That place and person prohibition doesn't exist under books and records and the accounting controls, right? So what the SEC has done, particularly in the civil context now, is that they have stopped looking necessarily at the anti-bribery portion specifically, and they have turned those violations into a books and records and accounting function because what inevitably happens is companies aren't putting the bribes in their books, right? These payments happen, they happen in cash, they typically don't filter their way back to the books. And so the SEC then, without that jurisdictional restriction, can reach out to the person or to the company and say, you violated our accounting regulations, you as an issuer, you as a person that touches that. And that's another way that they've been sort of trying to reach out to foreign companies. The reason I say all of this is because we're sitting in Turkey, right? And sometimes it's inconceivable that like the U.S. can reach out to a Turkish company, right? Now, this is setting aside U.S. companies doing business in Turkey or subs or people who are on the stock exchange. This is totally foreign companies, right? The U.S. is looking for ways to enact their laws and regulate them here, just like they have done in the sanctions regime. It's no surprise. I would not be shocked at all if in the next little bit we see, because as Kathleen said earlier, SEC, DOJ are putting their people in place. The new administration is up and running. They have said this is a priority. We are hearing a lot of chatter out of the fraud section at DOJ that we are just getting started. We are ramping up. There's going to be a lot of stuff there's going to be a lot of activity. It's been slow so far this year, but going into next year, I imagine we're going to see a lot of stuff, and a lot of it's going to be pretty cutting edge, I think, in terms of their trying to reach out and pull jurisdictional issues into the fore so that they can enact these laws in further places.
That's a mouthful.
That's a mouthful. It's interesting, though, and I think your perspective on this would be interesting. Sitting in Turkey, dealing with general counsel here in Turkey, what's been your experience with companies and their take on all this? When they talk about this to you, is it, what's the conversation like?
It's difficult to answer in this perspective, mainly because maybe 10 years ago my answer would have been slightly different when even in sort of multinationals or subs in Turkey, compliance, knowledge and awareness and maturity as to sort of Fcpa regulations maybe was at quite an early stage. Yeah. Or you had a lot of multinationals coming into Turkey and extending their reach by buying companies that were previously their distributors in Turkey. In that sense, for those types of clients, about 10 years ago, it was very much getting down and explaining the very concept that you explained in terms of the long reach of the US government and the very purpose that this legislation holds. Because particularly, as a lot of compliance professionals in the audience will agree, when talking about to Turkish companies, when talking about Fcpa or doing the training or trying to raise awareness, the initial reaction was, well, this is an American law, how is it applicable to us? And trying to get that point through. So I think, particularly in the last decade, definitely in terms of sort of integration of economy, prevalence of multinationals coming in, awareness as to Fcpa and other anti-corruption and anti-bribery acts and the general sort of maturity as to compliance, that's become a lot easier to explain. But it's now raising the maturity level and the awareness of, as you were saying, solely Turkish companies and individuals who, because either they don't regard themselves erroneously as not being within the scope of application of the Fcpa, even if they are, for example, in terms of trading or having a presence in the United States, or even if they're not readily within the scope of it, not understanding that there are numerous other steps that this reach can be applied to them. It's getting that across. It's also, I think, at this point, again, for strictly Turkish companies, the general compliance readiness awareness suffers somewhat from the fact that Turkey doesn't have its dedicated anti-corruption or anti-bribery act. It's heavily regulated under the Turkish Penal Code and a number of other legislative measures. So it's trying to get that notion across. So both in terms of compliance awareness and maturity, and also having them understand that this is not just a foreign law that is applicable to multinational companies or subsidiaries in Turkey. But again, I would say my answer is very different from when I first started off, along with Alto and Orçun, going to medical companies, particularly sort of pharmaceutical and med tech companies, and then trying to train their distributors and trying to train their sales staff in Turkey. It was a lot more of a struggle trying to get the notion that this law from another country that did not sort of have an direct impact on their commission or their sales model and how that was applicable to them. So the maturity has increased, the awareness level has increased, but still sort of purely companies focused on Turkey or Turkish entities, it is, I would still say, a struggle just getting that initial information to get them to comprehend that this is something that is very much in their life, and it may not be directly, first of all, it might not be explicitly and directly regulated under sort of a specific Turkish legislation either, but there are provisions within other applicable legislation that will harm them, both on a personal liability level and also in terms of in the recent additions to the law of misdemeanors, in terms of large administrative fines that can be issued against the companies themselves.
So should we turn to our audience for some questions?
Have we talked that much?
Almost.
What time do we?
12:15. I know that people are scheduled to go about their days, but if you want to have some final remarks, please
I wanted
have
to
my
ask you
guess,
one
but-
question though, which I think is important. What's your experience been in the Turkish landscape? Related, like FCPA is one thing, right? But then there's UK Bribery Act, and you've got Australia jumping in. You've got all these other companies, particularly UK, which Turkey and the UK have about the same trading matrix as the US at this point in time. How are companies, in your experience, dealing with this like multi-jurisdictional enforcement that we're seeing, where SFO and FCPA issues are coming together, in this more global economy?
It's a good question. I mean, it depends on the size and the previous experience of the company. I think companies that have previously underwent internal investigations or have seen their name pop up in the news, even though no action has been taken, I'd say they're a lot, from our experience, they're a lot more willing to contemplate and take preventative action in terms of having these SOPs, having these reporting structures, and having these policies in place. But again and again, we do come up against, particularly if, for example, the situation that I just was, a name popped up in an article, but no subsequent action was taken. Then there are situations where these policies or SOPs are sort of in name only, and because they remain unchallenged, they remain they're not updated, they're not revised as regularly, and again, it's the compliance function or the compliance professionals within the company aren't afforded the importance that they should be, particularly considering the points that they lie upon in terms of keeping track of and enforcing the myriad of different anti-corruption legislation that we're talking about for different countries. So I would say that balancing it all still for companies of medium scale seems to be more of a challenge. Larger multinationals with a full compliance department with experience in this, that have previously been burnt by this, are a lot more willing and a lot more active in terms of monitoring, in terms of having a good monitoring program either internally or externally. But in terms of more medium companies or sort of Turkish, purely Turkish companies, then balancing it all is still an area that needs to be developed, I would say, in my experience.
Okay. And then I guess the one last thing that I think is important to touch on, that I, in my personal practice, have seen a lot recently, talking to clients and them contacting us and thinking through problems that they have, is the issue of like third-party vendor diligence, right? Not really, you have your know your customer issues, but a lot of companies, a major hole in almost every industry are third-party vendors, right? And we know that's where most FCPA complaints come from. But as part of your compliance program, right, that's an area where you can reduce risk significantly, right, by just doing some diligence. I'm guessing if you're a company of any substantial size, I was talking to one the other day, it's a major U.S. company, they have something like 12,000 third-party vendors, right, that do everything from put the toilet paper into their bathrooms to running IT issues. But they had a significant threat pop up, right, in sort of a different context, but an internal person that was dealing with one of their vendors. The vendor ended up sending information to a third party that was very, very protected, proprietary, and it caused all kinds of issues. what happened is after all of this, they went back and did diligence on that third-party vendor and found out that for a number of years they had had their registration pulled for the particular industry that they were in. Nobody knew. Nobody had asked. They were a legacy vendor from a acquisition that they had made a number of years ago. And so, in terms of controlling the risk, particularly in an FCPA environment where third parties are the cause of most of these problems, being ahead of that in your compliance program and going through and auditing those, not only when they come in, if you're getting a new vendor and doing the diligence then, but thinking about, well, what about these vendors that I have that are, came in with, 3 executive teams ago that we just used because that's the person that's been there forever and they've done a good job and that's totally fine. Companies should think about going through auditing, having questions for those legacy vendors that maybe they've never paid that much attention to. But that's another box you can check, that if you ever run into a problem, you can say, look, I did everything I could to make sure to minimize the risk ahead of time. And I can tell you from experience, talking to DOJ, talking to SEC, prosecutors and regulators again and again and again, they do take it seriously. They will look, they ask, here are our guidelines. Have you done these things? How many of these things did you do? How effectively did you do them? And they use that in making their determinations in the long run. And if you can sit there and say honestly, and as Altu's saying, good faith, that I did these things, I did them to the best of my ability. This one got through, but I flagged it. I had a procedure to do an investigation. I did the investigation. I'm here telling you about it now. There is a better than good chance that they are going to say, well done, thank you for giving it to us. We are going to, have you go on your way. Because at the end of the day, they're not in the business of putting companies out of business. They want to do exactly what we're talking about today, which is they want to regulate and make it fair across the market. And that's one way to do it.
Thank you.
Thank you.
All right.
Questions?
Well, questions from the audience.
It was dense and it's a long day.
It is, but certainly the questions are one of the most important parts.
Thank you. This is Umut, and thank you, 3 of you. And it's real nice to have it 2 years later in Istanbul. So, very good speech. Actually, so when you were speaking on the FCPA, I was imagining of some countries that, force companies, FCPA can be more scary than the local legislations as well. So we can tell this honestly. My question is, we know the third parties are very important. So sometimes in many cases, in FCPA cases, they are playing a key role in the investigations or in the wrongdoings actually. So imagine a case, just based on your experience, imagine a case that, it's found maybe, many years later, this third party who conducted the wrongdoing is not there anymore. We are not working with them. Maybe it's not reachable somewhere. Okay, but their witnesses, they're as being subject or they being this witness of the case, their testimony is very crucial, and you're representing the attorney you are investigating, conducting this investigation. So without reaching these to key people, to key subjects, so how do you defend, this is a big missing in the puzzle, so how you mitigate these situations? And as you know, so there is no any local exposure on this country, so they can come and give and witnesses, etc. So how do you deal with these situations? Thank you.
Sure. So just to boil your question down to make sure I've got it right, you've got a company, there was wrongdoing engaged in by a third party several years ago. They've gone off to wherever, you can't get a hold of them anymore, but this issue is there, you've identified it and want to do something about it, but it's after the fact. Look, you have to, I'm going to put two different hats on here too, right? As an investigator, right, my job to do an independent, credible investigation with a purpose of, clearing the issue and making determinations about reporting is one thing, right? The question becomes, are those people reachable by U.S. authorities, right? If I, as the company here in Turkey, say this guy's in Algiers somewhere, I can't get a hold of him, what am I supposed to do? Engaging in the process, right, of an investigation really is you're going to be able to get a lot of information, right? You're going to be able to talk to those people who were talking to them. You're going to have their communications. You're going to have the, sort of the record of what occurred in that case. So you can put a lot of it together. The question becomes, as a practical matter, do you engage in a full-scale investigation based on that? And at the end of that particular investigation, do you report it, right? Because if and that's a judgment call, that's a business call that you have to make. Counsel and the executive committee would sit, or whoever we're reporting to, and say, here are all the pros of doing the full-scale investigation and reporting it, right? But there are cons to that too, because the fact of the matter is, if those guys are gone, you can't get a hold of them. Chances are the U.S. government can't get a hold of them. So how is this ever going to come to light unless I say something about it, right? And in those cases, if you're doing a confidential investigation, you may choose to continue to keep it confidential, which you are totally entitled to do. And the cost-benefit analysis of doing that is important, because you don't want necessarily to reach out to U.S. authorities for something that is not an issue that you think they are going to do anything about in every instance, right? But you may want to do, for internal issues, to learn lessons, to fix policies and procedures, you go through those things and then correct issues internally. The other hat I'll put on is if I'm your defense attorney, right, which I've also been called in to do by investigating law firms, right? You come in and they say, we've done this independent investigation, we have turned over the information, but for whatever reason it was very egregious and they're going to continue on with a prosecution or other regulatory action. We come in as the defense attorney, right, because you can't to segregate out the independence versus what is then a very non-independent obligation, right? It is my job then to advocate for you. Being that person, I may say, look, I don't want to contact them. If they're gone, they're gone. Let's make sure we never hear from them again. And maybe giving the company very different advice than if I'm the one that's asked to do an independent investigation. So I think it's a complex thing that would likely end up in lots and lots of meetings doing that trust thing that we talked about earlier, right?
Any thoughts on that?
I think Brad summarized it perfectly. I don't think I can add anything to that.
Good, that's on that.
Well, thank you very much for the enlightening panels. It is fascinating as it was 2 years ago, and giving us this opportunity to be part of it and learn from you. My question is related to the other aspect of the Fcpa or in kind of practices. What is the situation for a newly acquired company? Because you're not part of that organization up until D1, on the date that their shares being registered in the name of you. And what happens if anything went wrong in the past, which you couldn't identify during the due diligence stages? So which kind of a strategy or the potential actions to be taken by the new buyer?
Yeah, so that's an interesting question, and it's a very good one, and it's something we could have talked about for a long time, but we didn't have time. There is this sort of cottage industry in the U.S. now of doing FCPA due diligence, right, and sanctions diligence, right, where firms like ours who historically have done the investigations and the defense work are now being asked by our corporate departments to come in and advise them on these acquisitions. You know, can you tell us in the due diligence process what happens? But to your question, which I think is, if during that process you don't identify a past action, they consummate the merger, acquisition, or whatever it is, they are one company. That company is then, I'm assuming, trying to implement their controls and do the training and all the things that you would do in that instance. And then something pops up, right? And can the parent company be responsible for that past conduct of the new company? And it's I can't think of a case off the top of my head that has dealt with that issue, but it seems to, well, I can't think of one. There was a motor company, but this is in the sanctions area, and so I'll draw a comparison, which is U.S. company buys foreign company. Foreign company had dealings that would violate U.S. law. Historically, they told them not to do that anymore. They did it anyway. The U.S. held them responsible for the forward-looking violations, but did not hold them responsible for the historical violations. So in the FCPA context, it would be very difficult under U.S. law to hold a U.S. acquiring company responsible for the acquired company's past conduct, right? Sitting here as a defense attorney, I can think of a lot of arguments why that would not fly, right? Not the least of which is they weren't my agent. I had no responsibility over them. I had no agreement with them under conspiracy law to do any of this, and therefore I am not responsible. Now, that doesn't stop necessarily the U.S. from coming in and saying that company, as it existed at that time, violated, and we are going to penalize them as that entity. But if you merged or acquired liabilities, right, then potentially you were responsible depending on how the corporate documents read. I think that they may go back and say, well, you acquired liabilities. This was an existing liability, whether you knew about it or not, and therefore you are responsible for the penalty. But I imagine most prosecutors and folks at the SEC are practical people. They're not there to they are there to make your life difficult. As a practical matter, but that's not their intent, right? They have a job to do. They're very professional people. All of my experiences with them have, shown that they take their job seriously and they're trying to do the right thing as a general matter. And I think there are a number of arguments as I sit here thinking about how I would advocate on behalf of a company to make that go away. Particularly if that company was proactive in saying, I identified this, I have investigated it, here's what I found, here's the information. You can guarantee that we're not going to do it again because we've implemented all of our controls and we're very serious about compliance on this front. That SEC, DOJ would strongly consider taking a pass at that. I think that's...
Yeah. I mean, I don't have anything to add in terms of responsibility as doing sort of past acquisition, but just to pick up on something that Brad was saying, and again, it feeds into compliance programs and also compliance considerations. We've seen, particularly in the M&A area, we've seen compliance professionals being dragged increasingly into the whole M&A process. And again, that's more of a law firm management and operation aspect, and also choosing and working with a fully equipped and well-equipped external law firm, but it is sort of both in terms of FCPA sanctions, compliance professionals, data protection. Obviously, labor law was always a concern in terms of M&A projects, but we have seen increasingly specifically drafted, also both general, but also in terms of specifically addressing different compliance risk areas for any such acquisitions. So for compliance professionals or internal counsel working for companies that do engage in a high volume of acquisitions, particularly again if the main company or the core business is something that readily will fall under FCPA compliance, it's also important to include external counsel or make sure that the company regards the internal compliance professionals as an important element of this M&A process, because it's very easy to cry about it once, as Brad was saying, once this acquisition has happened, then it's looking at a division of responsibility or if there was any prior knowledge, but it's becoming increasingly important as industries are becoming more interconnected, as they're becoming more technical, involving these compliance professionals at an earlier stage just to prevent the situations that you brought up occurring down the line.
The one other thing I'll say to your question is thinking about it from a company versus individual perspective, right? U.S. authorities may make very different decisions about the individuals involved as opposed to the company level, right? And so internally, if the individuals who are involved in that conduct at the acquired company are still there, the acquiring company would want to think seriously about taking action against them proactively to, take whatever administrative action you have to take, including terminating them to get rid of those people, because that would be a factor that regulators or DOJ would consider in making their ultimate determination.
If no other questions, I guess. Thank you for coming and thank you for listening to us. We'll be around if you want to grab some more things to eat. I don't think much is left, but I guess Alto might want to do some closing remarks.
Thank you, dear speakers. Let's have a round of applause for this great thing. I'm gonna switch to Turkish. Çok teşekkür ederiz. Bugünkü etkinliğimiz bu kadar. Sizlerle beraber güzel bir etkinlik oldu. Böyle uzun süreden beri özlemiştik fiziki etkinlik yapmayı. Almayanlar için bizim white paper'ımız dışarıda var. Aynı zamanda soft copy halinde hepinize mail atacağız. Bugün aynı zamanda bir kayıt yaptık. Kaçırdığınız yerler olabilir, tekrar dinlemek istediğiniz yerler olabilir. Onu da size editleyip atacağız. Bizim amacımız bilgiyi paylaşmak. Sizlerle beraber öğreniyoruz. Çok güzel sorular geldi. Aralarda çok güzel katkılar oldu. Dolayısıyla 3. etkinliğimize inşallah görüşürüz. Hepinize değerli katılımlarınız için teşekkür ederiz. İyi günler.